Blue lights in your mirror. You pull over, heart already thumping even though you've done nothing wrong. The officer walks up, and within about 30 seconds, you're going to be tested. Not by a breathalyzer, but by something far more common. A carefully worded question, a casual comment. A request that sounds like small talk, but is actually designed to get you to hand over more than the law ever required you to. Most drivers walk away from a stop having said far more than they needed to, done things they weren't obliged to do, and never once realized they had a choice at any point. A smaller number swing too far the other way, refuse something they were legally required to comply with, and end up arrested for it. Both groups got the law wrong, and today I'm going to make sure you're neither one of them. I'm Oliver Bennett, criminal defense solicitor here in England and Wales. Over 15 years, I've represented more drivers than I can count who got tangled up, not because they did anything wrong on the road, but because they didn't know which requests during that roadside conversation were genuine legal requirements and which were simply techniques designed to get them talking. So let's go through exactly how these stops actually work, the tricks worth knowing, and the calm, simple lines that keep you protected every time. Picture a man driving home late one evening. Call him Daniel. He's had nothing to drink, done nothing wrong, but he gets flagged down at a checkpoint. The officer leans in and says, "Evening. Mind telling me where you've been tonight?" In the first version of this story, Daniel wants to seem helpful, so he tells them everything: where he's been, who he was with, why he's out so late, and keeps talking even as the questions keep coming. None of that was ever required of him. He simply handed the officer a full narrative of his evening, none of which had anything to do with the actual reason he was stopped. In the second version, Daniel's heard that you don't have to talk to the police, so when he's asked for his driving license, he folds his arms and says, "I don't have to give you anything." That's actually wrong. As the driver of the vehicle, he does have to provide that. He's just been arrested for a genuine offense, in a situation where a document he was legally required to hand over sat in his glove box the entire time. Same stop, two completely opposite mistakes. And here's the thing, neither version of Daniel was being deliberately foolish. Both were simply reacting on instinct in a stressful moment, without ever having been told clearly where the actual line sits. That's not a knowledge gap unique to Daniel. It's the default position most drivers are in, right up until the moment blue lights appear in their own mirror. Let's make sure you're never either version of him. Here's the foundation. Everything else in this video sits on top of. Under Section 163 of the Road Traffic Act 1988, a police officer in uniform can require you to stop your vehicle for essentially any reason or no stated reason at all. Failing to stop when required is itself an offense. This power is genuinely broad, and there's no real point arguing about it at the roadside. But here's what a lot of drivers don't realize. Being stopped is only the beginning. Everything that happens after that, being asked questions, being breathalyzed, having your car searched, runs on entirely separate legal powers, each with its own conditions attached. The officer stopping you doesn't automatically unlock all of them at once. Let's go through the tricks, one at a time. Trick 1, the routine stop that isn't actually routine. Here's something the courts have specifically addressed, and it's worth knowing. Police are allowed to stop any vehicle for any reason under Section 163. But the courts have made clear that officers cannot use a minor, invented, or genuinely pretextual traffic reason purely as an excuse to fish for a breath test or search with no real underlying suspicion at all. Using a routine stop purely as a disguise for something else can, in the right circumstances, amount to malpractice. In practice, this is difficult to challenge in the moment, and it's not the roadside conversation to have. But knowing it exists matters, because it means the phrase, "just a routine check," isn't automatically a magic phrase that unlocks every other power that follows. If a stop feels like it had no genuine traffic-related basis at all, that's exactly the kind of detail worth raising with a solicitor afterwards, not something to argue about standing next to your car. Trick 2. Mind telling me where you've been tonight? This is the single most effective trick in the entire encounter, and it works because it doesn't feel like an interrogation. It feels like conversation. Once your documents are sorted, officers will often keep talking. Where have you been? Where are you heading? Who were you with? None of this is required. You are not obliged to narrate your evening to a police officer during a traffic stop. The problem is that staying quiet can feel awkward, and a lot of people fill that silence simply because it feels rude not to. A simple, polite line handles this perfectly. I'd rather not get into that, but I'm happy to give you my documents. You're not being difficult. You're simply not handing over free information that has nothing to do with the actual reason you were stopped. Trick 3. The documents you genuinely do have to hand over. Now let's cover the flip side because this is where refusing genuinely becomes a problem. Under Sections 164 and 165 of the Road Traffic Act 1988, if you're the driver, you can be required to produce your driving license and to give your name and address, along with the name and address of the vehicle's owner, if that's not you. Refusing to provide these when lawfully required is itself an offense. This isn't the moment to talk about a general right to silence. Behind the wheel, this specific power is real, and you comply, calmly, without a debate. Keep this exception crystal clear in your head and separate from everything else in this video because it's the one drivers most often get backwards. Trick 4. You don't mind a quick breath test, do you? This is where a lot of people assume they have no choice at all, and mostly they're right, but not always, and the reasoning matters. Under Section 6 of the Road Traffic Act 1988, an officer can require you to take a preliminary roadside breath test if they reasonably suspect you're driving, attempting to drive, or in charge of a vehicle with alcohol in your system, or if you've committed a moving traffic offense or been involved in an accident. Refusing without a reasonable excuse is a genuine offense under Section 6(6), carrying a fine and penalty points. Here's the trick worth knowing. Officers cannot simply breath test every driver at random with zero suspicion whatsoever. There has to be a genuine trigger, whether that's a moving traffic offense, an accident, or a specific reasonable suspicion of alcohol. In practice, at an organized checkpoint, that threshold is usually easily met. But if you're stopped for something entirely unrelated and immediately asked to blow into a device with no explanation at all, it's entirely reasonable to ask calmly, "Can I ask what's prompted the breath test request?" If there's a genuine answer, comply. Refusing at this stage is a real offense, and reasonable excuse is interpreted narrowly by the courts. Nervousness, reluctance, or wanting to speak to a solicitor first do not count as a reasonable excuse for refusing a roadside test. This is genuinely one of the few moments in this video where the advice is simply, comply, then raise any concerns afterwards. Trick 5. The escalation from roadside test to the police station. If you fail or refuse the preliminary roadside test, you'll be arrested and taken to a station for an evidential breath test under Section 7 of the Road Traffic Act 1988. This is a different, more serious stage. Refusing this evidential test, again without reasonable excuse, is an offense under Section 7(6), and it's treated essentially the same as being over the limit, carrying up to 6 months in custody, an unlimited fine, and a mandatory minimum 12-month disqualification. The trick here isn't really a trick. It's a trap people set for themselves by assuming that once they're at the station, Delay tactics or vague objections will help them. They almost never do. If you have a genuine medical reason you cannot provide a sample, that needs to be raised clearly and will typically require supporting medical evidence. This is not the moment to invent an excuse on the spot. Trick 6. Mind if I take a quick look in the car? We've covered this in detail in a previous video on this channel about officers asking to search your boot, but it's worth repeating here because it comes up constantly during traffic stops, specifically. A routine stop does not, by itself, give an officer an automatic right to search your vehicle. That requires either your consent or genuine reasonable grounds under Section 1 of PACE, a real, specific, articulable reason, not a hunch. If you're asked and you're not sure whether real grounds exist, the calm response is, "Can you tell me the specific grounds for wanting to search the car?" If there's a genuine answer, comply with the physical search and save any objection for later. If the answer is vague, you're entitled to say clearly that you don't consent, while making equally clear you won't physically obstruct anything, because obstruction is a separate offense in itself, regardless of whether the underlying search turns out to have been lawful. Trick 7. Reading your behavior as evidence. Here's something worth understanding about how officers are trained to think during a stop. Nervous hands, hesitant speech, avoiding eye contact. Officers are taught to notice these things, and in a police report, they can end up described as signs of something suspicious. The problem, of course, is that being stopped by the police is inherently stressful for almost everyone, guilty or not. You can't fully control how nervous you appear, but you can control what you say about it. If you feel like your nerves are being read as guilt, a simple, honest line works far better than silence or over-explaining. "I'm just a bit nervous being pulled over, that's all." Said once calmly, it removes the ambiguity without inviting further conversation. Trick 8. Keeping you talking after the reason for the stop is over. Sometimes an officer has clearly finished the original purpose of the stop. Documents checked, no issues found, but keeps the conversation going anyway, hoping something else comes up. Unlike some other jurisdictions, English law doesn't have one single clean rule setting an exact time limit on how long a stop like this can reasonably continue. But the general principle under PACE and ordinary public law still applies. Any ongoing detention has to be for a genuine, identifiable purpose, not simply extended indefinitely on the off chance something turns up. If a stop feels like it's dragging on well past its original purpose, a calm, simple question is worth asking. Is there anything further you need from me, or am I free to go? This does real work. It forces the officer to either identify a genuine ongoing reason to hold you there or confirm you can leave. It's not confrontational, it's simply asking for clarity. Trick 9. Getting you to admit something small off the record. Officers are trained interviewers, and one very common technique is a casual, friendly-sounding comment designed to get a small admission. "You were going a bit quick there, weren't you?" Phrased almost like it's already agreed rather than an actual question. Here's the important part. There is no such thing as off the record with a police officer. Anything you say during a stop can be written into a report and potentially used later. A calm, simple response avoids the trap without being rude. "I'd rather not comment on that." You're not obliged to confirm or deny a suggestion like this, and doing so almost never helps your position. Trick 10. Knowing that silence has a slightly different rule here. If you've watched American police shows, you'll know the Miranda warning. You have the right to remain silent. The UK version is different, and it's worth understanding properly, because it's not quite as simple as staying completely silent throughout. The official police caution reads, "You do not have to say anything. But it may harm your defense if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. That middle part matters. Unlike a straightforward right to silence, staying completely quiet in a formal interview and then raising a defense for the first time in court can, in some circumstances, be commented on later. This doesn't mean you have to answer every roadside question. Plenty of what we've covered above remains entirely optional. But if things escalate to a formal interview at a police station, the safest approach is usually, "I don't wish to answer further questions without speaking to a solicitor first." That protects you properly and gives you the chance to get proper advice before anything you say is used to build a case either way. Trick 11. Splitting you and your passengers up. If you're not traveling alone, you'll often notice officers separate the driver and any passengers, speaking to each of you individually rather than as a group. This isn't an accident. It's a deliberate technique because two people questioned separately are far more likely to give slightly different accounts of the same evening, different timings, different details, even when nothing improper has happened at all. Officers then compare those small inconsistencies afterwards, and inconsistencies, even entirely innocent ones, can be written up as suspicious. The fix here isn't to coordinate a story with your passengers. That's obviously not what I'm suggesting. It's simply to recognize the technique for what it is, and to apply the same principle we've covered already. You're not obliged to give a detailed account of your evening to either officer, regardless of how the questions are framed. If each person in the car simply and politely declines to elaborate beyond what's actually required, the entire technique loses its power, because there's no narrative being compared in the first place. It's also worth knowing that any suspicion the police develop about one occupant of a vehicle doesn't automatically transfer to everyone else inside it. If an officer wants to search or question a passenger specifically, they generally need some basis connected to that individual, not simply the fact that they happen to be sitting in the same car as someone else. Trick 12. The helpful suggestion that you get out of the car. Sometimes, rather than directly asking for something, an officer will suggest you step out of the vehicle just to have a proper chat, or, "So we're not shouting through the window." This can feel friendly and reasonable, and often it's entirely innocent. But it's worth knowing what it changes. Officers generally can require you to step out of a vehicle where they have a proper basis to do so, and refusing to get out when properly asked isn't usually a sensible fight to pick at the roadside. What matters is what you do once you're standing there. Being outside the car doesn't create any new obligation to answer questions you weren't otherwise required to answer. The same rules from earlier in this video still apply standing on the pavement as they did sitting behind the wheel. You comply with genuine requirements and you politely decline to elaborate on everything else. Let's walk through how a stop should actually go, start to finish, if you know what you're doing. You're stopped. You comply calmly. You don't argue about Section 163. When asked for your license, you hand it over without hesitation, because that's a genuine requirement. When asked open-ended questions about your evening, you politely decline to elaborate. If a breath test is requested with a genuine reason behind it, you comply. This is not the moment to test the law. If asked to consent to a search with no clear grounds given, you say clearly that you don't consent without physically resisting. If the stop seems to be dragging on with no clear purpose, you calmly ask whether you're free to go. And throughout all of it, you stay polite, because raised voices and defensiveness are the one thing that can turn a routine stop into a genuinely bad night. This is the principle I keep coming back to on this channel, because it's the difference between people who walk away clean and people who don't. If you think an officer has overstepped, searched without real grounds, held you longer than necessary, pushed for a breath test with no genuine basis. The roadside, late at night, with blue lights still flashing, is never the place to win that argument. You comply with what's genuinely required, you stay calm, you note names, numbers, times, and exactly what was said. And if it turns out something was done unlawfully, that's the moment for a formal complaint, or proper advice from a solicitor who can examine the whole picture properly, including, where relevant, whether evidence should be excluded under Section 78 of PACE because of how it was obtained. Let's bring it all together because I want this to genuinely stick. Remember the starting point. Section 163 lets police stop you for essentially any reason, but that's only the beginning. Everything after runs on separate powers. Remember the genuine requirements: your license, name, and address as the driver under Sections 164 and 165, and a breath test where genuine grounds exist under Section 6E. These are not optional, and refusing is a real offense. Remember what's optional: narrating your evening, explaining your nerves at length, consenting to a search with no clear grounds, and answering casual, off-the-record comments designed to get an easy admission. Remember the pivot questions. What's prompted this? What are the specific grounds? And am I free to go? 3 calm sentences that turn guessing into knowing. Remember the quieter tricks too. Passengers being separated and questioned individually to create small inconsistencies. The friendly suggestion to step outside the car that doesn't actually change what you're required to say. And the casual, off-the-record comment that was never really off the record at all. None of these rely on you doing anything wrong. They rely entirely on you not realizing there was a choice in the moment. And remember the golden rule underneath all of it. Comply with what's genuinely required by law. Stay calm and largely quiet on everything else. And if something felt wrong afterwards, deal with it properly through a complaint or a solicitor, never by arguing it out on the roadside at night, with blue lights still flashing in your mirror. Because here's the truth of every single one of these tricks. The officer is very often relying on exactly one thing, that you don't know which parts of this conversation are genuine legal requirements, and which parts are simply techniques to get you talking. The moment you know the difference, the entire encounter changes. I'm Oliver Bennett. Know your rights, because the people who know them are the ones who drive away clean. I'll see you in the next one. Disclaimer: this video is for general information only and does not constitute legal advice. Every situation is different. If you're facing a specific case, speak to a qualified solicitor as soon as possible